Support comes from the Missouri Forest Products Association, providing more than 41,000 jobs in the production of wood pallets, railroad ties, white oak barrels, hardwood floors, and more. Details at choosewood.com.
Welcome to St. Louis on the Air. I'm Sarah Fensky. Every month, we convene a legal roundtable to talk about the issues of the day involving the justice system in Missouri and Illinois, a panel of experts to share their insight into the law. Now, at last month's roundtable, we talked a lot about Mark and Patricia McCloskey. The day before, the two St. Louis-based personal injury lawyers had brandished guns at protesters walking past their mansion in the Central West End neighborhood of St. Louis. Our panel of experts discussed that day whether they had a legal right to do that. Did it make a difference if the guns were loaded? What about the fact that the McCloskeys live on a private street? Well, 1 month later, it is again our legal roundtable, and America is still talking about the McCloskeys, and so we will too. There have been some big developments in the case. The pair now faces felony charges filed by St. Louis Circuit Attorney Kim Gardner. They've also become a cause celeb for some conservatives. Missouri Attorney General Eric Schmidt is already trying to get those charges thrown out. Governor Mike Parson is considering a pardon, and they haven't even entered a plea yet. So joining us today to discuss the case against the McCloskeys and so much more is a top-notch panel of legal experts. This week, that includes one of the Legal Roundtable's founding members. Mark Smith is an Associate Vice Chancellor and Dean of Career Services at Washington University. Mark, welcome back to the show.
Thanks.
And we're also joined today by Nicole Gorovsky. She's a former prosecutor, now in private practice at Gorovsky Law. Nicole, welcome.
Thanks for having me.
And last but not least, today we're joined by Dave Roland. He's the co-founder and director of litigation for the Freedom Center of Missouri. Dave, welcome.
Thanks so much, Sarah.
So, Nicole, as a former prosecutor, I want to start with you in this conversation today. The McCloskeys have been charged with unlawful use of a firearm. What does that mean, legally speaking?
So unlawful use of a firearm is a Class E felony in Missouri, and basically it just means that a person knowingly exhibited in the presence of one or more persons any weapon capable of lethal use in an angry or threatening manner. It does not have to be loaded to be considered a weapon readily capable of lethal use. There's actually case law on that in Missouri. It does have to be a real weapon. So it can't be like a play gun that looks like a real gun. So that's what that means, that it's readily capable of lethal use. That's it.
So it's a pretty simple thing, legally speaking, although I know that nothing is ever that simple, legally speaking. That's why we have a panel. There's always a lot of discussion about what actually means what. Mark, I want to ask you about something. There has been a lot of talk about the castle doctrine as it comes to this case. The protesters were walking on a private street. Does the fact it was private affect whether they have a right to defend the street the way they might ordinarily have a right to defend a home? Is this even worth asking this question?
No, I think it's a very good question. I think a lot of the facts in this case, if it does go to trial, which it may or may not, it's very factually dependent. So it'll depend on what the jury thinks. Did they feel threatened? Were they on their property or not on their property? You know, there's conflicting stories about whether the gate was broken. And so I think, and this public street, it's going to depend on, even that's a factual question, it seems, because the little research I've done, and I've talked to some other lawyers about it, they said a lot depends on how the street is typically used. So if it's used as a public street, it's a public street, even if it's maintained privately. In this case, because it was gated, that could cut the other way. Who knows? I do think this castle doctrine, and, you know, I always feel, or not always, but in this case, you know, there's a difference between what's right and wrong and what's good judgment and what's legally protected and sanctioned. Missouri has a very expansive castle doctrine law that just was passed amended a few years ago. I think it would probably protect the McCloskeys. I'm not saying what they did is a good thing or a right thing, but I think it would probably protect them. I don't know what the other panelists think, but I think that will be the ultimate issue in this case.
Dave Roland, I'd love to hear your thoughts on the castle doctrine as it might apply to this case.
Yeah, and just as full disclosure, I actually helped draft the amendment that was adopted back in 2014 to Article 1, Section 23 of the Missouri Constitution. So what makes that provision unique to our state is that it specifies that there's a right not only to keep and bear arms, but also that you have the right to bear ammunition and accessories typical to the normal function of those arms. And it also specifies that you get to bear those arms in defense of home, person, family, and property. So I think that I don't think there's any question but that they likely violated the law about unlawful exhibition of firearms. The question is whether that can constitutionally be applied to them in light of Article 1, Section 23. I think it is arguable that, particularly given the fact that some of these protests have turned violent, or at least there have been people who have become violent, kind of not necessarily as part of the protests, but adjacent to the protests. There's a reasonable argument to be made that they felt like they needed to act in defense of their property. They needed to be proactive in defense of their property. Now, I'm not expressing an opinion about whether or not that is a winning argument here, but I think it's at least a colorable argument.
So, Dave, they could maybe they could be convicted by a St. Louis jury. You think they would have good grounds for appeal, saying that state law gives them an out here?
I think the preliminary question would be whether this statute can be applied to them. If I'm representing them, I immediately raise a motion to dismiss, and I say, well, no, the Constitution prevents the state from even engaging in this prosecution. I make that a preliminary question. And then once the court has decided either yes, the state can proceed with the prosecution, or no, they cannot, then you get to the statutory issue. But yeah, I think that that's a very significant defense they could raise. I express no opinion as to how the courts might ultimately rule on it. I will say that Missouri courts have not given this amended provision very much impact. In fact, they said it did nothing to change the law. So who knows? But I think that's going to be the question that's going to be before the courts.
Nicole, former prosecutor, I'd love to hear your thoughts on Dave's legal strategy he's outlined here. Certainly a possibility of something their lawyer could do.
Sure, I'm going to agree and disagree with Dave Roland, because I agree in the sense that he's pinpointed correctly the issue. I mean, the issue is going to be whether or not the Castle Doctrine applies. I disagree. If I'm the prosecutor, my strategy, of course, is that it does not apply. And the reason that I think it does not apply is because it has to be someone who is entering or remaining unlawfully on your property. It can't just be anyone's property. It has to be your property. And there was no evidence in this case that these people were entering or remaining unlawfully on the McCloskey's property.
Well, but when we talk about the private street, can they say the street is their property? I certainly don't feel that it is, but legally, could they make a compelling case, Nicole?
So apparently there had been some legal wrangling over that in the courts, that they had attempted to sue their own homeowners association to claim that it was their property, but I don't think they won that. And so I think there is a clear legal ruling here that was not their property. And so I think that Mr. Roland is absolutely correct that there is going to be a pretrial motion to dismiss, but I don't know how they're going to win that. And I also want to disagree just real fast that it's a Second Amendment issue. I don't think it's a Second Amendment issue. This does not come down to the right to bear arms. It comes down to whether you can commit a criminal offense with those firearms.
I want to get to another question that has to do with this firearm. This was a fascinating twist. Christine Byers, who's basically the best police reporter in town, she's with 5 on Your Side, KSDK, she reported that Mrs. McCloskey's gun wasn't functional. She writes that a prosecutor ordered the crime lab to field strip the handgun, found it had been assembled incorrectly. The firing pin spring was put in front of the firing pin, which was backward, made the gun incapable of firing. Firearms experts put the gun back together, and the correct order and test fired it, they found that it did work then. Now, the McCloskey's attorney, Joel Schwartz, said that the McCloskeys intentionally misplaced the firing pin on the gun and that it was in that condition when Patricia McCloskey waved it at protesters. Does that make any difference? Dave Roland, any thoughts on that bizarre little twist on this?
I think it absolutely makes a difference. So from what I understand, the assertion is that they had modified this weapon to use it as an exhibit in a trial. And so if in fact the weapon was not in a condition where even if it had been loaded, it could have fired, I think that makes a difference as far as the elements necessary to prove the crime that's been alleged. At least as far as Mrs. McCloskey is concerned, I don't think that it impacts Mr. McCloskey and the weapon that he was holding.
Nicole, would you, if you were the prosecutor, would that trouble you, or do you feel like you could proceed with this case and argue that this gun still qualified?
So I haven't researched that exact issue in the case law. My guess is that there isn't that exact issue in the case law.
It does seem extremely unusual.
Right. It's pretty unique. But based on the law that says it doesn't have to be loaded to be, a lethal weapon, I'm going to think that's not going to fly as a defense.
We did get a great question from Twitter. MBJSTL1 asks, why wasn't Mrs. McCloskey's gun confiscated during the search of their home? She was instead allowed to turn it to the police the next day and then claimed it was inoperable. It does kind of raise a question. If they'd gotten it sooner, it might be just a little bit more evidence that might make people believe her. Any thoughts, any of you want to speak to this, of why that hadn't happened? Nicole?
I think the issue there was it wasn't in their home during the search warrant. If I have this correctly, I think they had given, for some reason, that firearm to their attorney, and it was in his office.
They'd moved
And
almost
that's
too
why that
swiftly, is your sense.
Yes.
That was my understanding as well. I thought that Al Watkins had the weapon itself at the time that they conducted the search.
That
It was
again,
almost like they were trying to establish chain of custody, that they gave it to him and so they couldn't tamper it. I don't know if that does that or not, but I think that was the thinking.
They might have thought that would be a point in their favor, Mark, to have it turned over to their attorney. Okay. Well, that was a great question from one of our Twitter users. And if you have a question for our panel, at this point, we're not so interested in hearing more opinions about the McCloskeys. There's a lot of cable news you can watch for that. But if you have questions about this or anything else that we're talking about today, you can give us a call at 314-382-8255. That's 382-TALK. You can also send us a tweet at STL on air, or you can email us at talk@stlpublicradio.org. Now, Kim Gardner, who brought the charges here, she's taken a lot of heat for doing this. Senator Josh Hawley wanted her investigated even before she brought charges. Now, Attorney General Eric Schmidt is attempting to intervene. Some people have raised a question about whether he has the right to do this. Dave Roland, thoughts on whether Eric Schmidt can do this?
So it's an extremely unusual situation. And again, it goes back to the recent amendment of Article 1, Section 23. So one of the things that was added to that constitutional provision is it says that the state of Missouri shall be obligated to uphold these rights and shall under no circumstances decline to protect against their infringement. So the Attorney General's office has used that in a case involving the ban on weapons on University of Missouri property to justify intervening into the case as a party to argue that this constitutional provision protects citizens' gun rights. So the strange thing here is that's not precisely what the Attorney General's office did. They didn't intervene as a party. They filed a friend of the court brief saying, hey, we think that this should be dismissed. It's really questionable whether they actually have any authority to file a friend of the court brief in the trial court, and particularly when they're asking for a remedy that the defendant themselves has not yet requested. It's just a very, very strange set of facts. I don't know how the courts are going to deal with it. It is, I believe, literally unprecedented.
Nicole.
And particularly when they're charged with the responsibility to handle any kind of appeal. And so I hadn't thought about what you said, Dave, though, this shall language, that they have a affirmative duty. And so I don't know, I'd have to think about how you'd balance that if it went to, if there was the necessity of an appeal. I mean, but that's an interesting argument. I still think they have an affirmative duty to handle the appeal. And I think filing this amicus brief really puts them in a difficult position to be able to do something like that.
Nicole, any thoughts about the Attorney General's actions here?
Yeah, I mean, I think, I used to work at the Attorney General's office. I think taking a step back and looking at the big picture, this is a very dangerous proposition. The Attorney General shouldn't be picking and choosing prosecutions to get involved in. I mean, there are certain prosecutions where we probably wish that the Attorney General would get involved in, and they say that they don't have the authority. This one, they've decided that they do have the authority. It's very dangerous when political people start deciding when they do have authority and when they don't. And intervening like this is just, I think it's terrifying for, allowing prosecutors to do their jobs across the state.
We're talking to Nicole Gorovsky of Gorovsky Law, David Roland of the Missouri Freedom Center, and Mark Smith of Washington University. We need to take a quick break, but we'll be back shortly. We'll talk a little more McCloskeys and then move on to some other legal matters. This is St. Louis on the Air on St. Louis Public Radio. That's 90.7 KWMU.
Support comes from Missouri Forest Products Association, committed to sustainable and sound conservation of the state's forests, which support more than 41,000 Missouri jobs, resulting in a $10 billion industry. ChooseWood.com.
And now back to our conversation. We're talking to our legal roundtable, which has a host of heavy hitters. That includes Dave Roland, the co-founder of the Missouri Freedom Center. We're also joined by Nicole Gorovsky of Gorovsky Law and Mark Smith of Washington University. And we've had a lot of thoughts and questions here about this St. Louis couple. This is Mark and Patricia McCloskey. They're facing charges for brandishing guns at protesters. We were talking about just how unprecedented it is for the state attorney general to weigh in this case at this early stage of the game here. And Dave, I know you were hoping to respond to something before we had to take that break.
Right. So before we went to the break, there were concerns expressed at the awkward position the attorney general would be in by stepping into a criminal prosecution and taking basically the defendant's side in this. And that, I believe, is the perceived conflict is that eventually the attorney general's office might be responsible for defending a successful prosecution down the road. I take a really different perspective on this generally, though, because for all of our elected officials, and I think most importantly, the attorney general, their primary responsibility, the thing they take an oath to do, is to uphold the Constitution of the United States and the Missouri Constitution. And although almost every attorney general candidate you will ever talk to says their primary responsibility is to defend the laws of the state, I actually think that's incorrect. I think they're looking at it the wrong way. I think the proper way for an attorney general to view any given case or any given dispute is, number one, to say, well, what does the Constitution require? Are there rights here that actually should be protected? And if they should be, I think that the attorney general should stand up for those rights. Now, they can appoint independent counsel to represent the position that the law must be defended, and they can hire outside counsel to do that. But I personally believe that the attorney general has a responsibility to stand up for the Constitution, even if it is contrary to the laws of the state.
Seems like.
What about if you have two constitutional issues? I mean, you have the First Amendment rights of the protesters. I assume you're saying the McCloskeys have a Second Amendment right to take their guns out, which I'm not sure I really see that as an infringement on the Second Amendment. What's happening here, but I mean, you would recognize there's a First Amendment right too of the protesters, right?
Yes, except that no First Amendment right is violated by private actors. The McCloskeys are private actors. So they are incapable of violating the First Amendment rights of the protesters. The question is whether a government official was trying to prevent them from expressing themselves in a protected way. And again, I think the issue here is that these political officials, these elected officials, their utmost duty is to uphold the Constitution. And if in appraising any given situation, they believe that the Constitution requires a particular outcome, I think that's what they should be advocating. Again, I don't mean that there should be no one to represent the opposite perspective. I think that perhaps they need to hire someone to take the contrary position if they cannot in good conscience do it themselves. But I do think the highest authority is to protect the Constitution.
Nicole, is that a practical position for Dave to be taking? I mean, if the AG decides to zip around every time somebody's in violation of the Constitution, would they be able to do anything else?
Well, again, I'm going to agree with half of what Dave said. So I agree with the fact that the Attorney General takes an oath to uphold the Constitution, but the Attorney General also takes an oath to uphold the laws of the state of Missouri. And the part where Dave said that the Attorney General should uphold what the Constitution should be, I think I very strongly disagree with. We have the judiciary for that, and we have the legislatures who can change what the law should be if we think that that's a possibility, but that is absolutely not the Attorney General's job. So the Attorney General has to uphold the laws of the state of Missouri, and I think that's very clear.
We did hear from some of our listeners on this. Matt says, you sit on your porch and point a gun at everyone that walks by and see how long it takes to get arrested. It really is a crime. Dean writes on Twitter, why do prosecutors not file all applicable charges? In my high school civics class, if that man had been in his yard with a bat yelling at people, that is simple assault with a weapon. Is Dean correct about that? Nicole, I see you nodding.
Yeah, I mean, there's certainly a possible assault charge here as well. I think prosecutors use a lot of judgment in filing charges. Half that judgment is figuring out what you can charge, and then the other part is figuring out what deserves to be charged, what's the easiest to prove, what is presentable to a jury. There are a lot of factors that go into those charging decisions, and so I think here, the unlawful use of a weapon charge, I mean, literally, I read off the elements at the beginning of our segment, and it's a very simple charge.
So the prosecutors are looking for the case they know they can make.
Right.
Chelsea on Twitter says, what are the panel's thoughts on the McCloskeys starting pretrial diversion per their attorney? I'm just saying innocent folks generally don't jump through those hoops. Mark, any thoughts on that?
No, I didn't even know they were doing that. But I mean, I guess they're just trying, what are they going to do? Take some safety classes or something?
Yeah, this is news to me as well. Has anyone else heard this, that they're starting pretrial diversion? Would that be a way to make the charge go away, or Nicole?
It's not uncommon, though. I mean, so a lot of people in the criminal system who get private attorneys, their private attorneys will have them start doing things that will make them look good in front of the judge, or that their attorney can take to the prosecutor and say, look, my client is doing this thing to make amends. Can you lessen what the punishment will be? That's a very common thing.
Okay. Well, that is good to know. And thank you for answering that question. It's great to have somebody who has that prosecutorial experience here to walk us through some of these things. One more question I wanted to get into. As we know, next Tuesday is the Democratic primary here in St. Louis City and St. Louis County. Kim Gardner is facing a tough battle. Mary Pat Carl, a former prosecutor with a lot of experience, has some good funding taking her on. Do you think this could possibly hurt Kim Gardner with city voters? I can certainly see a lot of city voters who are going to be very enthusiastic about this prosecution, but could this play a different way? Mark, what do you see, I guess, at this point as Gardner's outlook on this election?
I don't see this being the big, I mean, personally, I don't see this being the big issue in that election. I think, and I know Mary Pat Carl, she was a student at the law school when I was dean of students over there. And I think, the issue that a lot of people have with Gardner, and I wanted Kim Gardner to succeed. And you see all these people leaving, both we had the public defender, somebody from the public defender's office on our show a year or two ago criticizing Gardner's office. And so there's a concern, I think, by a lot of people with just general competence. Too many people have left, and cases aren't getting filed, and it seems like things are falling through the cracks. And I mean, she certainly came in as a change agent, but I think even the people who saw her as a change agent have had some disappointment. So I think that's what the race will try to be about. Mary Pat Carl will say, I can bring competence, good, strong law enforcement, and Kim Gardner is saying, I'm bringing change, and it's going to be messy for a while.
And certainly, I don't think anybody who has opinions on Kim Gardner or her philosophy is going to be surprised that she ended up picking up this case. This is very much in her wheelhouse. Dave Roland, any thoughts on that?
No, I think that's a purely political question, and I stay out of purely political questions.
That is a wise policy. We are talking to our legal roundtable. That was Dave Roland of the Missouri Freedom Center. We're also talking to Mark Smith of Washington University and Nicole Gorovsky. We do need to take another quick break here, but coming up next, we're going to talk about a controversy in St. Louis County that is getting just super interesting and frankly kind of bizarre. This is St. Louis on the Air on St. Louis Public Radio. That's 90.7 KWMU.
Support comes from the Missouri Forest Products Association, committed to conservation and careful management of the state's forests to make them more resilient and better habitats for wildlife. ChooseWood.com.
Welcome back. We are talking to our legal roundtable today. We have wrapped up talking about the infamous McCloskeys of St. Louis City. We're going to switch our focus to St. Louis County, and we'll be talking about a very interesting case there with Mark Smith of Washington University, Nicole Gorovsky of Gorovsky Law, and Dave Roland of the Missouri Freedom Center. Now, this case involves a serious allegation involving a local attorney named Jerome Dobson. Before I get into the details, I do want to reiterate it is a week before the primary election that determines who runs St. Louis City, who runs St. Louis County, for many key offices. This is what we call silly season. The most incredible mud does tend to get slung. So I want everyone to just have that perspective in mind as we talk about this case, which there are some serious issues in this case. So Attorney Jerome Dobson represents St. Louis County Police Lieutenant Colonel Troy Doyle. And Doyle was passed over earlier this year in his bid to become chief. It was a pretty big surprise. Now, over the weekend, a firestorm erupted when Attorney Dobson announced that Doyle had filed a claim with the Equal Opportunity Employment Commission alleging racial discrimination. He says that Lieutenant Colonel Doyle was passed over to be chief because he's black and because the Police Foundation, some private funding for this government office, wasn't okay with that. But County Councilor Beth Orwick says it's Dobson whose actions deserve scrutiny. She accuses the lawyer of seeking to, quote, effectively extort her boss, County Executive Sam Page. She says Dobson basically offered to keep this under wraps until after Page's tough primary is over next week in exchange for a payment of about $3.5 million for his client. That allegation has now been forwarded to federal authorities. Mark Smith, did Jerome Dobson cross the line by offering to settle this quietly and by mentioning the election in part of that?
Yeah, so I think there were actually two kind of complaints. One was this idea of, I'll settle the case quietly before the election. And then the second one was, that Orwick said that, and also you were going to his chief of staff, Winston Calvert, who's, while he's a lawyer, he's not the legal representative for the county. And they're suing the county, not Sam Page. And so I think both of them are on the line, and a lot's going to be depend on what exactly was said. And I'm a little less concerned about the going, with the government agencies. Sometimes you're going there for information, and but I just think you could file charges with the bar exam. I'm not sure they would, or with the bar examiners. I'm not sure they would go that far. Mm-hmm. Probably get a reprimand, but nothing more than that. I just don't see that being, unless it was exactly how they said, and they've got some good facts to back it up. Mm-hmm. I'd be interested in what others think.
It's interesting if the Office of Disciplinary Counsel, they sort of govern lawyers. If they're not interested, right. It's hard to imagine the FBI would be. But on the other hand, I don't know. Does everyone agree with that? Nicole?
Well, that's a very good point. Taking it to the FBI, I'm not sure what they're investigating here.
Yeah, I think they're asking for Dobson to be investigated for potentially extortion. But man, when I read the story, I thought, where is the line for attorneys? It kind of sent a little chill down my back, and I myself am not even an attorney. Nicole, what about you?
Yeah, I think part of this is incredibly fact-based, right? Because we don't
Right.
know exactly what was said and we don't know exactly what happened in the room where apparently they had a meeting. I will say, I don't know Jerry Dobson, but I know he's been an attorney in St. Louis for a very long time. I think he's been doing these cases for a very long time.
Right.
Never met the guy, so I can't say I know anything about him. But the one thing that the county councilor wrote in the letter, I mean, this was a very sort of scathing letter, and there are some pretty heavy accusations in the letter. And one of the things that she says is that she threatened that if they did not pay $3.5 million to you and your client, meaning Dobson and his client, I find it kind of hard to believe that Dobson would say, pay me and my client, right? Attorneys know that they say to settle the case, right? They don't, I mean, that's what Michael Avenatti got in trouble for out in California, is asking for a job for himself and, to get paid a whole bunch of money. That definitely crosses the line. Somehow I doubt that Jerry Dobson said, pay me personally, but that nevertheless, that's what the letter says. So, I mean, like I said, we weren't in the room. It possibly happened. I don't know. And then she cites a state law saying that Jerry Dobson threatened to make the complaint public, meaning the MCHR EEOC claim, which is how you start an employment discrimination case. The state law she cites basically says that the commission cannot make the complaint private. It doesn't apply to attorneys, and it's not a ethical rule for attorneys.
He would
So
have had
that
every
really,
right to go public with this complaint, you're saying. Her letter makes it sound like he wouldn't have, but you're saying that's a misreading of the law.
right. I mean, there are ethical rules about what attorneys can and cannot say to the press, but that's not one of them. And then the other thing is, I'm always very concerned about people who write letters and make them public about someone making an ethical faux pas without actually reporting them to the bar.
Hmm.
If you're a lawyer and you think that a bar ethics rule has been violated, you have a duty to report it to the bar. You don't have a duty to make it public and, start a nuclear war. Your duty is to report it to the bar. It does not appear that she has done so. So in my mind, that's a little bit specious.
So, Nicole, you have some skepticism about this case. In fairness to Beth Orwick, the county council, this letter came out after Dobson did push the nuclear button. They did go public with this, but I think that's still a fair point. Dave, do you have thoughts on this case?
Yeah, I mean, the first thing that my mind went to when I heard about this case was the Avenatti situation. And I think what really put Avenatti in hot water was he seemed to expressly condition his willingness to, well, basically, he told Nike, if you do not give me X amount of money, I am going to go public and make statements that are going to cost the company billions of dollars because its stock is going to tank.
Mm-hmm.
And so kind of that express threat to do something that would damage the company unless they paid him off. I think that that's what led to his conviction. With this situation here in St. Louis County, I don't know if the allegations about what was said would even rise to that level. I'm not familiar enough with the situation or with the law on that topic, but that's what it made me think of is perhaps we're in that area if there was an express demand made. The one thing I want to add is making reference to the primaries, I don't think makes a difference at all. I mean, I think that saying, oh, we're going to bring this information out before the primary, it's going to have this political impact. I think that's different than saying we are going to cause you financial damage. But again, this is not my area of expertise. So
Sure.
perhaps I'm not the best source on this.
I did want to pull this back to talk about the bigger picture here, and that is Lieutenant Colonel Troy Doyle's discrimination complaint. This isn't just someone getting passed over for any promotion that would be available to somebody who'd put in the time, and and by all accounts, this Troy Doyle was a superstar. But there's only one chief of St. Louis County Police Department. So if race plays a factor in who's chosen, is that a problem? And can you sue for discrimination if you're not chosen for something that's kind of one of these, it's almost like being mayor? Nicole, what are your thoughts on that?
So years ago, it used to be that race just had to be a contributing factor to be considered employment discrimination. Now it actually has to be a motivating factor. So that's a little bit of a higher standard. So I mean, I love to try to simplify the law for people that it's just that simple. If he can prove that race was a motivating factor in getting passed over for this promotion, then he can win. If he can't, he can't.
Well, so
And,
let's
and
compare this to interim St. Louis City Police Chief Lawrence O'Toole. When I was at the Riverfront Times, we made so much fun of this guy because he did bungle a lot of things. He kettled protesters and tear gassed people in the street. He was up for full-time chief. He didn't get it. He said it's because he's white. Well, I think it's fair to say at that point, with some of the issues in St. Louis City, they probably were a little more open to wanting a black chief to lead that department. Did O'Toole have a case? Mark Smith?
Well, it's just the city and the county are different. I mean, back in the day, so I was on the police board for the city of St. Louis, selected a chief. The mayor was one of the 5 members, but that board, by majority vote, selected the chief. In the county, my understanding is the police board selects the chief. The mayor gets some influence, but ultimately it's this board that's making the decision.
That's right.
So, the county executive can say, I'm going to go to the mat for you. I'm going to do my best, but he's not making the decision here.
Mm-hmm.
So and like you said, when you're selecting a chief, you can prove, under a race discrimination case, there's these 4 elements. You got to prove you're in protected class. You didn't get the job. You were qualified, and they gave it to someone else. But then the other side gets to present a business reason, and then you get to go back and say, yeah, but that's pretextual. And unless they have some evidence that the decider was, using racial, I think it's going to be really tough to win.
Dave?
Yeah, I think that analysis is correct. I think that the critical question in this situation in St. Louis County is that Doyle, from what I understand, is claiming that he was specifically told that that Page was getting pushback on appointing a black police chief.
Mm-hmm.
If a jury believes that, yeah, someone specifically said, we don't want a black police chief, we do not want to hire a black police chief, I think he wins. But what it may boil down to is a swearing contest. I'm not going to put it past somebody to have actually put something like that in writing, but unless you have kind of a smoking gun that says, by the way, we do not want a black police chief, it's difficult to make the burden of proof, to meet the burden of proof necessary to say, oh yeah, this was the motivating factor in why we chose one candidate over another. I think it's likely to ultimately end up in front of a jury, assuming that there's no settlement. And then it's just going to be who's more persuasive to the jury.
Nicole, thoughts on that?
Yeah, I think that's exactly right. If you combine what Mark and what Dave said, I mean, everything that Sam Page promised Doyle, I think, is irrelevant because everybody knew there was a commission that was going to make the decision. And Page can't say he had the commission in his pocket because that wouldn't be ethical or correct. So what it's going to come down to is, yeah, that accusation that the commission gave pushback on hiring a black person. And if it turns out that they can prove that that was the motivating factor in not hiring him, then he can win.
He would have a
I
case.
thought the pushback was coming not from the commission, the police commissioners, but from this outside foundation. So if you've got a foundation putting pressure on the chief, and then the chief endorsement becomes more lukewarm, but ultimately the commission makes the decision, I think it becomes more difficult to prove there.
And Mark, I believe your recitation of the facts there, that is correct. And so that does add this other layer. That just becomes a greater complication for Attorney Jerome Dobson or whoever's arguing this case. Okay. Well, this is one we're going to have to keep an eye on. Like I said, it is silly season. I want everyone to take all of this with a grain of salt, but this is a fascinating case, and obviously it's absolutely appalling if the police foundation is going around pressuring St. Louis County not to get a black police chief because they are not open to having a black police chief. I think everyone on the panel could agree that if those facts are true, this is a major scandal that we will be talking about quite a bit even after the election. Now, there's another case I want to talk about today. We have so many more cases we want to talk about today, and also talk about the bar exam. We'll get to that in a minute. But I want to update people on something we've talked about on this show. We've actually had former Governor Jay Nixon, on the show to talk about. In March, Missouri Attorney General Eric Schmidt filed a lawsuit against televangelist Jim Baker, who's based in Branson. And Schmidt alleged that Baker had touted a product called Silver Solution as a treatment for the coronavirus. He said that consumers could be victimized by the false information. Now, Jay Nixon represents Baker. He said and explained on our show that he thought this was a religious freedom case and that Baker's freedom was being violated. Now, this month, a federal judge said he had serious concerns about Nixon's religious freedom argument. He also said the plaintiffs were not able to demonstrate irreparable harm. So the judge declined to block Arkansas and California officials from investigating Baker. This case is obviously going to continue to play out. But Dave, what are your thoughts on this one?
So I want to point out that there are actually two distinct issues here. One is the case brought by the Missouri Attorney General's office, and the other is the actions that have been threatened by the attorney generals in California and Arkansas. The Missouri case is going to focus on a statute here in Missouri, the Religious Freedom Restoration Act, that sets a much higher bar for the protection of religious liberty than the U.S. Constitution does. So the Missouri Attorney General is going to have to overcome that bar. He may still be able to do it, but it's there. In the case involving the other states, they're only going to be looking at the First Amendment and the other aspects of the Constitution that Baker has raised as a defense. One of the most important questions here is how sincere is Baker's religious belief?
Boy, and is that a question for the ages or what? Haven't we been wondering that very question now for decades?
Yeah, so courts are not permitted to question the validity of the belief itself. What they do is they ask, does the person sincerely believe this? So even if a belief is completely bizarre, if a citizen can show that they sincerely hold that belief, well, then it's an act of worship that may or may not be constitutionally protected. But if the jury or the fact finder says, no, we actually don't believe that they sincerely believe this, well, then the First Amendment element, the religious liberty element, goes away entirely. I personally am somewhat skeptical that suddenly Jim Baker had this revelation that Silver Solution or whatever it's called, this product that he profits from, is his divine purpose. But he's entitled to make the argument. We'll just have to see who's persuaded.
Nicole, what are your thoughts on this case?
Yeah, I also tend to agree that that Missouri Attorney General is not going to win this case, but actually for not even constitutional grounds. So it's my understanding that Jim Baker has actually stopped selling this stuff. He's taken everything down. And for a temporary restraining order, you have to show some kind of exigency, that there's some kind of emergency going on. If he's already ceased this behavior, I don't think there's any he can show any necessity for a temporary restraining order. So it could be resolved just that simply. But on constitutional grounds, I think even if you can get past, the concept of did he really believe in this stuff, I think then you also have to balance that with the harm to society. And I think that's a problem as well.
Well, that's going to be an interesting case. It sounds like Attorney General Eric Schmidt in Missouri might have some problems, and yet in some other states, it still might be enough to shut down Jim Baker. So we'll keep an eye on that one. In our final 5 minutes here, something I think is very important to discuss is what is going on with the Missouri bar exam. And Mark, you work in higher education. I know this is an issue that's probably tops on your mind. What's going on here in Missouri? I understand it's going on like right now in Missouri.
Right. I think today is the second day of the bar exam. And so my condolences go out to all those people. I cannot remember a more miserable 2 days of my life. That was just horrible. As your listeners may know, to become a lawyer in Missouri, you go to law school and then you have to pass the 2-day bar exam. This year, a number of states, and each state licenses lawyers independently. Most states also require a bar exam. The state of Wisconsin, if you went to one of their 2 in-state law schools, Marquette or University of Wisconsin, and you have a certain GPA, you don't have to pass a bar exam, you just can become a lawyer. Because of the coronavirus and because of, I think some states have recognized the civil unrest that's going on and the effect it's having on people, have said, we're going to waive the bar this year and just if you graduated from law school, that's enough. And Washington State is doing that. Utah, there may be some other states, and it doesn't matter where you went to law school. Missouri has said no. They're saying you need to take the bar exam. And what they've done is everyone has to mask up. Instead of 1 big ballroom where we all took it, they now have 2 hotel ballrooms. But it sounds like a very difficult situation. Now, the other thing about the bar exam is, there's some controversy about bar exams because, the way it's justified is we say, well, we do it to protect the public. And then, I took the bar exam over 30 years ago. I can still be a lawyer. I can still practice law. I haven't done it in 30 years. I'd be a real danger. But
Mark, you put this on the record here.
Yeah, then don't let me. I like to say I have a private practice, very private, which means I don't let anyone in. But it's also a way to keep out new entrants. To restrict the number of lawyers. And so
you are preaching to Dave's choir right now. Dave,
I'll let Dave take it over
would
from
you
here.
like to see the bar exam just go away, not just in coronavirus? Is this a protection racket for lawyers here?
Let me lay a little bit of foundation. The reason that my wife will eternally know how much I love her is I took a second bar exam so I could come to her home state of Missouri. So
That's love.
I have endured 2 of these, passed them both. I don't believe that the bar exam is actually an effective measure of whether someone is going to be a good attorney or not. I don't think it serves the purpose that it is, at least purported to serve. So I think that I think it's something that should go away. Whether it is expressly protectionist, trying to limit the number of attorneys so we can all charge a lot more in fees. I suspect that was the purpose of bar exams. I don't have hard evidence to that effect. But ultimately, I think that the legal profession as a whole would be better served if the bar exam did not exist. I think that we can safeguard the practice of law without forcing people to jump through this incredibly onerous, incredibly expensive hoop.
We've got just 1 minute left here today, and I've got one question for you guys. I'm hoping for a quick yes or no answer from each of you. If a young lawyer who's stuck in one of these ballrooms, taking this bar exam, breathing in the unfiltered air, contracts coronavirus, would they have a good case if they sued? Nicole, yes or no?
Maybe.
Dave, yes or no?
I'd like to say yes, but probably not.
Probably not. Okay, Mark, any thoughts on that?
One would think they would have made them sign releases or something.
A liability waiver. There you go.
Yeah, right.
Well, we feel for anyone who is taking the bar today, and we truly hope that you do not contract the coronavirus. I should not laugh about this. This is actually really serious, and these liability waivers are such a troubling thing we're all faced with these days. But I do want to thank my legal roundtable for joining us today. We did it all remotely. No one contracted coronavirus during this show, and that is indeed a good thing. So, Mark Smith of Washington University, thank you so much for joining us today.
Thank you.
And Dave Roland of the Freedom Center of Missouri, thank you for lending us your insight.
Always a pleasure, Sarah.
And Nicole Gorovsky of Gorovsky Law, last but not least, thank you so much.
Thank you.
This is St. Louis on the Air on St. Louis Public Radio. That's 90.7 KWMU.
Support comes from the Missouri Forest Products Association, providing more than 41,000 jobs in the production of wood pallets, railroad ties, white oak barrels, hardwood floors, and more. Details at choosewood.com.